Let me talk a little bit about the process of what it takes to put a whole plan together. So normally when clients first come in, the first meeting is a whole lot like everything I've just gone through. And if clients are hearing it for the first time, by the end of the first hour of me speaking, their eyes are glazed over, they're feeling overwhelmed, and there's so many decisions they didn't even realize they were gonna have to make, they just wanna run out of the office. Which is fine, I understand that situation. Go home, think about it. We're never trying to rush anybody. We don't want you to do something that you're really not totally interested in doing. So we're not pushing anything. So normally they will come back for a second meeting, which we call the design meeting. So when we have the design meeting, at that point, they've decided what kind of trust they want. They're zeroing in on what their goals are, what they're trying to achieve. We've talked about all of the options, and then we get all of the information that I need to create the documents. At the end of the day, you're gonna have a 3-ring binder full of documents that's a complete plan with everything that we've been talking about. But at the design meeting, all I'm gonna do is get information. Once I have all of that information, we can start creating the documents. And the second meeting we have is what we call the signing meeting. At the signing meeting, that's where you're gonna sign all of the documents that we've had prepared for you. You're gonna be seeing them for the first time. Usually what we do is send you a summary of the trust prior to that meeting so you're familiar with it in some general way. But at the signing meeting, it takes me an hour to an hour and a half to just go through every document, make sure you understand it, and get you comfortable with it. Then you can sign it, and then we're gonna have another meeting that we call the funding meeting. And at the funding meeting, you're gonna sign a new deed, sign the documents to send to the broker, sign all of the documents to get everything into the trust. But the other thing we do at that funding meeting is that we're gonna make any changes to the trust that you want so that you're thoroughly satisfied with it. So after the signing meeting, you can go home, read it, study it, memorize it if you want, because at that last meeting, we'll make any changes in it so that you're thoroughly satisfied with it. And that's the process. We've done it thousands of times at this point, and it seems to work. I think we have a few happy clients. Some of them are here today. You happy?
Mm-hmm. This is a question you might not
Yes.
be able to answer. How much does all that cost?
A lot. No, you can, I'm not the cheapest. You can always find somebody that will create a trust for you. The real problem comes in comparing apples and oranges, because we build so many bells and whistles into it. A lot of times when you're quoted a price for a trust, they're not including that part of the process. How much time does that take? A lot. So in general, without all the specifics, because I never want to say what something's going to cost until I know the scope of the engagement. You know, like I have a client who'll come in, a lady will say, you know, I have a very simple situation and I want a trust, and we look at it and say, well, that's not too bad, you know, and I quote a fee, and then she says, well, what do you have, you know, before I know all the assets? This one lady had, she liked CDs. She didn't have a brokerage account. She had 30 banks and a little CD in every one. You know? So we didn't know the scope of what we were going to do. But plus or minus, if you're an individual, it could cost $3,000. If you're a married person, it could cost $5,000 or $6,000. If you're coming into the office and you say, my mom is going into a nursing home, we haven't done any planning yet, it's a crisis planning. I don't do a whole lot of that, but the lawyers around here that do a lot of that would charge $15,000 to $20,000 to do that point. I always compare it to what's it gonna cost you to go to probate? You know, if you got a house and some broker's account, and that's worth $500,000, and you go to probate, you're already paying more than $5,000 just in a probate fee. So, for the value that you're getting, I know it's hard to believe that I've had a lot of clients come back to me and tell me I don't charge enough. But I think what we charge is a fair amount for the amount of work that goes into it. And it's hard to describe the amount of the work because of all of the time it takes to just do all of the different things that we are doing. But those are ballpark figures. Yes?
Just on your behalf, we had another attorney do a previous trust and also had to go to probate with the death of somebody in the family through this attorney, and we were much more pleased with your trust and
Because it was funded.
the way you handled it, yes.
Well, thank you. You can pick up your check on that.
What is the minimum that a person should have?
We get that question all the time, what's the minimum? So my starting point is always, what are your goals and what are you trying to achieve? A trust is nothing but a tool, and it's a great tool in the right circumstances. So you may not have much at all, but need a Medicaid trust. You may not have much at all if you're trying to take care of your spouse at home and you qualify for VA. I had a client, little old lady, sweet lady, lived in Baltimore. She had virtually nothing other than she owned a house. I don't think the house was worth over $100,000. It was a row house in Baltimore. And she was elderly, and her son was living there with her, and a granddaughter was living with her. Sort of to be on the kind side, I could best describe them as knuckleheads. Right? So she has knucklehead 1 and knucklehead 2 living there. And she knows if she leaves the house to them, they're not going to maintain it. So we took the house and we put it in a trust, and she named her niece that was very responsible as a trustee. And she said, tell my son and my granddaughter, they have to pay the taxes, they have to keep the house up, they have to just maintain it. And if they do that, they can live there forever. But if they're not paying that, there's no other money, kick them out. So they live there 2 or 3 years, then the granddaughter starts whining, why should I have to pay taxes, right? You know, it was so little, she couldn't go anywhere else and rent an apartment for less than she had to pay, but she didn't want to pay, so kick them out, sell the property, and divide the money the way she wanted. She had nothing to speak of, but that trust was a great tool to solve her problem. So, depends on what you have and what you're trying to achieve. If the only thing you want to do is avoid probate, we don't need a trust to do that. You can either put someone else's name on the deed, so you die, they own it. You can do a life estate deed. You can give the house to your children now and reserve the right to live there. You can put someone else's name on your bank account. When you die, it's theirs. I mean, all those things are possible, but they all come with risk. I learned this early on. When I first started doing this work, I had a client, she owned a house, free and clear, and her brother was living with her, and she said, you know, I think I'm going to put my brother's name on the deed. I said, you know, I don't think that's a good idea. Oh, you know, he's a great guy, you know, then we won't have to go through probate. So she did it. Brother got these letters in the mail all the time. Congratulations, you're a qualified spender. You know, here's a credit card. So he took that credit card, and he took that credit card, and he took that credit card, and then he couldn't pay any of it back, so he went bankrupt. What assets did he have in his name? Half the house. Sister was crying, literally crying, when she wrote out a check to his creditors to save his house. So if you put somebody else's name on your account, bear in mind that you're exposing it to whoever their creditors might be. Or you put your child's name on your bank account and your child gets divorced. When they get divorced, what do you own? Well, here's this bank account. So you just need to be careful, and so that's why we use trusts rather than giving assets away directly to children, because it's protected.